Welcome to Legal 123s with ByrdAdatto. Legal issues simplified through real client stories and real-world experiences. Creating simplicity in 3, 2, 1.
Welcome back to another episode of the Legal 123s with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host, Michael Byrd.
As a business and healthcare law firm, we meet a lot of interesting people and learn their amazing stories. Brad, this season's theme is unintended consequences. We sometimes find ourselves in a situation that can be traced back to a seemingly inconsequential or unrelated decision.
Yes, Michael, and those who are in TV land will notice that once again we welcome back our series regular and partner, Jay Riero.
All right, Brad, before we get started, I got a very important question. Are we in the top 25 podcasts yet?
Worldwide, no, but for legal sports movie talk, I think we rank like number one in everyone's heart.
Yes, maybe we need to just form some sort of like polling entity that ranks podcasts.
I like that.
We can
start by just calling me and seeing what I think.
Have a fake trophy, kind of like all your best lawyer trophies.
Those are mostly, they're made out of paper, so I thought they were real.
All right, Jay, what do you have for us today?
Yeah, so today's story actually reminded me of a recent sports saga that had its own kind of little unintended consequence.
All right, well, for people living in Dallas, the most recent sports saga, they immediately think about a story that was the midnight trade of Luka from the Mavs to the Lakers, and then the story keeps going with the Mavs somehow receiving the number one pick in the NBA draft. That was a little bit of a sports saga. Is that what you're referencing?
Still too soon, Brad.
Still too soon. Okay.
Yeah. No, Brad. I'm actually talking something out west about the Utah Hockey Club, the new expansion team in the NHL.
Okay, well, I do like the NHL, but I'm not familiar with the story because we are a sports podcast, highly ranked. Hit us with the story.
All right. So the saga actually had been over the name. So you see, Utah Hockey Club was just a temporary name until a permanent name could be selected. And so what they did is they started with a list of 20 possible names, and as you would imagine, a very good decision. Let's put it to a fan vote to see what they can come up with, because that's probably going to be a solid decision.
Very solid.
And let's narrow it down to 6 finalists.
And there was some controversy because they had thousands of votes from the same place in Dallas. But despite the polling results, they did refuse to name the team the Utah Brads.
I know. I was so shocked at the AI component. Although the Utah Brad just rolls off your tongue. I don't know if you thought about that way. All right, name. All right, we got names going here. Jay, what name made the cut?
All right, so the 6 finalists were 1, Utah Blizzard, 2, Utah Hockey Club or Utah HC, the Utah Mammoth, the Utah Outlaws, the Utah Venom, and finally the Utah Yetis. So I'll have to ask both of you, which one would you have voted for?
Blizzard is kind of a cool name for a hockey team. I'm all right with that, but I think of like the drink you get from whatever that's Blizzard drink. But if I had a chance to write in, I think the Salt Lake Slap Shots would be pretty good.
Yep. There's your dad joke. I lean to the Utah Hockey Club. That sounds cool, kind of channeling the English Premier League.
Okay.
And the other ones just make no sense to me.
Well, I would say I'd have to vote for the Yetis, because what's more imposing than a big abominable snowman as a mascot? And actually, most people must have thought the same thing, because momentum actually built towards the Utah Yetis coming out the winner in the first few rounds of votes.
I do remember seeing something on ESPN or something about the Utah hockey team. I don't remember hearing them calling it the Utah Yetis.
Yeah, see, that's where the problem popped up. So while everyone, fans, players, were excited about the Yetis, there was a small little problem we'll just refer to as trademark infringement.
Mm-hmm.
You see, when the hockey club submitted their trademark application to the U.S. Patent and Trademark Office, or USPTO on the street, it rejected it because of the likelihood of confusion for consumers to all these other companies that had been using that brand name. And a database search actually turned up a number of third-party marks registered for use, and one of those was the Yeti Cooler Company.
Pause for a cheers with my Yeti.
Yeti. Well, I have one here too. That's really weird. And I'm sure that the Utah Hockey Club was surprised that Yeti was not happy to learn that someone wanted to use their name. I mean, I think the argument that Yeti could make is like, think of all the free advertising that we would give having a sports team use a similar name as this great cup of the Yeti sitting here next to me.
Yes, Brad, the classic free advertising defense.
Yes.
Kind of like fair use.
Yeah.
Maybe if they had agreed to make the mascot come to life cooler, they could have closed the deal, but they didn't. After all that momentum, it was back to the drawing board, and so they had to see what other possibilities were left. So they narrowed it back down to 3 to vote on: the Utah Wasatch, the Utah Hockey Club, and the Utah Mammoth.
Okay. So Utah Hockey Club is still the current name, and it was one of the original 6 finalists. And I think, if I remember right, you said the Mammoths were finalists too. Why Wasatch?
Yeah, so it was a new option that they threw in there. Apparently, it's named a local mountain range, and it was going to allow them to use some kind of mythical snow hill creature that was kind of in the form of a Yeti. So go back to
not
that.
Not a Yeti, but
right?
Very similar looking to one.
But it didn't last long because after the first night of voting, it became clear from the fans that they were not quote-unquote fans of that option. My guess is they probably got 0 votes or 1 from someone's mom. So they actually replaced it with the Outlaws, which was one of the 6 original finalists.
Yeah, and switching now from our sports talk to movie talk, I do love a good Western movie.
Yes.
So I'm a fan of the Outlaws. That's a good name.
Young Guns, Tombstone.
Exactly.
All right, I'm curious, Jay. What name won?
Yep, so the Utah Hockey Club will now be known as the Utah Mammoth. Apparently, mammoth fossils have been found throughout Utah as they thrived in the Utah's glacial terrain.
Seems very anticlimactic after all those other names.
Not very imposing to be named after a fossil.
Yeah,
Right.
Watch out for the fossil.
No live mascots there.
Yeah.
Yes.
Unless they bring them back. Mammoth mice.
So is there any connection whatsoever to today's story?
Yeah. So let's start with today's story with our character who's going to be an internal medicine physician out in Utah who's starting her own wellness practice, and let's call her Dr. Gretzky.
Gretzky. I love it. For those who don't know, Wayne Douglas Gretzky is a Canadian former professional hockey player. He was also a former head coach at one point. Played over 20 seasons in the NHL. It was kind of the 80s to the late 90s kind of guy. So for Michael and I, maybe, and those the older audience members might remember, he is considered the greatest player in the NHL history. And as such, I'm a big fan of this name, although Dr. Gretzky she has some big shoes to fill now.
Yes. Well, so she had been working out on the East Coast for several years, but wanted to return back to her roots and be closer to family. So she decided to relocate on the other side of the country and go back to Utah. And rather than join another practice or a hospital facility, she felt she was ready to take the leap, and she wanted to start her own wellness practice.
Yeah, for the audience members who have not started a practice before, I don't want to just bury the weight of that decision. Young doctors who start their own practice tend to be cut from a similar cloth. They have at least some level of adventurous spirit and definitely have a higher level of risk tolerance than your average doctor, because doctors are not trained on the business of medicine in medical school, and so it's a completely new discipline to venture out into becoming a business owner.
Yeah, and we as a firm love working with entrepreneurs, is the term of art that we've not coined, but we've heard enough times, because they get to take their passion for the clinical setting and the patient care, and then they roll it into their entrepreneurial vision about what it could become. So it's a lot of fun from that perspective.
Yeah, and Dr. Gretzky was no different. Moved back, started the process to build her practice, and she began by coming up with a name with a vision in mind, to Brad's point, and forming the practice entity with the state. The name she selected was Pulse Point Wellness.
Okay, that's an interesting name. Not immediately drawing a connection to anything. What was her inspiration?
Well, her passion was surrounding this whole health and wellness. And she had visions of building her brand and logo around a heart logo to kind of follow some kind of healthy heart marketing strategy.
All right, sounds like your typical idea of a health clinic. And did she have a trademark?
Brad, you throw these big words out and not back it up. So you're going to be assigned the vocabulary word for today.
Okay, well, I would say most our audience members already know trademark is intellectual property, also known as on the street as IP. It's an asset or something of value that's intangible creation of the human intellect. Most people, when they hear IP, they think about, as you said, trademark. But for others, there might be examples like copyright or patents. And to receive this protection of the IP, Jay said this earlier, you got to go through a federal government, and it's through the USPTO office or U.S. Patent and Trademark Office. And Michael, you often have said this in other shows or in speeches. You have a great analogy. Oh, strike that. He has an analogy. It's not great. It's average.
It's okay.
It's above average, maybe. When it comes to trademarks, can you share that?
Yeah, so it's important to understand. There's a perception that if you want to protect your name, for those that know about trademarks, that I go get a trademark and that's that. And it's, like us lawyers have with all the laws, it's more nuanced than that. And so the most important thing to understand when you're seeking trademark protection is, who was the first to use it. So I use the analogy of something back when Brad was a young lad and they had the land grab, people on the East Coast, going out west and, they would put a stake in the ground and that would become their land. And it's the same thing with trademarks. Like you see a name, you like a name, and you put your stake in the ground for that name. And that is the most important thing. If your first use of that name, then you're in a better position, even, regardless of the trademark application process. And so it's important to be grounded in that and then understand that trademark comes alongside that concept and bolsters those rights that you have.
Yeah, and so, Brad, to answer your question, no, she did not have a trademark, but she was pretty far down the road kind of with her vision. And, Michael, this goes to something you guys talked about in a prior season, but she had actually been in what you've referenced as stealth mode.
Yes, you are talking about our Season 15 building season where we had a trademark episode. Stealth mode means that you're starting to take steps towards using a mark even if you're not active yet. So this could include things like securing your domain names, social media handles to start, and, of course, also start putting together content that would be ready to launch when you're ready to put the stake in the ground.
Yeah, I started thinking, getting back to Dr. Gretzky, I mean, besides us being the #1 podcast for sports, legal, and movie talk, why did Dr. Gretzky come to us?
Yeah, well, so she knew she wanted legal counsel to just make sure she was setting everything up correctly and to help her get the necessary paperwork to start seeing patients. And at first, it was just going to be that she didn't need employment-related documents. It was quite yet. It was just going to be her initially while she was small and kind of getting going, getting that patient base built up. But the first order of business really was she was about to secure space. And so our first really to-do action item was to review and negotiate the commercial lease.
This is a common early step in the startup process. You kind of think about the list of things you need to do on the legal end to get your business started up. And, at the top of the list is getting your business structure and entities in place so that you have something. But one of the next things is to find that place where you're going to have your practice.
Yeah, and so we negotiated the lease, secured the space, and is pretty common. Still had some build out to do, so she was looking at about a 6-month time frame before she would officially open her doors. So she turned her attention back to the marketing, to realizing that vision, to start getting the word out, and even begin developing the sign that was going to go up in the space.
All right, Jay. So things are going very smoothly so far. She's found her attorney. You're helping with the lease. But as our very smart audience knows, this season is unintended
That's right.
consequences. So at this point in the show, I think they're waiting for you to really turn it up a little notch here, and something's about to happen, right?
Yes, Brad. So you see, about 2 months before she was ready to open her doors, Dr. Gretzky got an unpleasant surprise in the mail.
Now, going back to when our podcast, if we're talking movie talk, it would be in a horror movie, the surprise would be very gruesome. But because we're going to go back to the real world and the legal world, I'm assuming she might have gotten a nasty letter with very ugly words in it.
I'm guessing she accidentally received a bunch of letters from Dallas advocating for the Utah Brads hockey team.
No. Those letters ended up buried in the New Mexico landfill where Atari sent the ET cartridges. No, for once, Brad was right. Dr. Gretzky got a cease and desist letter from a multi-state hospital system based in South Carolina. Its name was Pulse Point Health System, and its logo contained a heart. The letter indicated that they had a federally protected trademark and demanded that Dr. Gretzky stop using Pulse Point immediately and change the name.
First off, for our audience member who don't know what Atari is, that was a game system. And yes, there was a terrible game for E.T., which was a movie for audience members who don't even know that part.
There's a very niche audience.
This is very niche.
Got Jay's
very niche
joke.
Yes. But going back, if you're not familiar with it, a cease and desist letter is really a formal notice demanding that an individual or an entity immediately stop something that could be hurting or allegedly an activity that could be harming another business or party, right? And it can take many different forms. It can come from a court or an attorney or some other even third party. And if it's issued by a court or the government agency, generally speaking, it's legally binding. You kind of have to stop. If it's sent by an attorney or a third party, it's not legally binding, but you should take a serious warning because it can lead to legal actions down the road.
Yeah, and these are emotionally terrifying for no matter who it comes from for a business owner to receive. So I'm guessing Dr. Gretzky must have been upset.
Oh, 100%. Absolutely. She had been building towards this brand vision and was already invested emotionally in what she had envisioned. And so the prospect of having to rebrand was just gut-wrenching.
Yeah, I'm sure she was blindsided with receiving this letter. But you said so close to getting her grand opening. So how did we approach this issue?
Yeah, so first we needed to verify everything that was talked about in the cease and desist. So we wanted to investigate the merits of Pulse Point Health Systems claims. Typically, we do two things. We check the USPTO database to confirm if there is a federally registered trademark that exists. And then if not, we determine whether there are any potential arguments that the brand trumps or they could actually coexist.
Yeah, I mentioned earlier in the land grab analogy this idea of first use being so important. Mm-hmm. Another really important concept is there a likelihood of confusion with the use of the mark? So just because they align, is it going to confuse the marketplace? And so it can be relevant from a risk perspective if you get one of these letters when a brand exists in another state. If that brand is only, a local mom and pop, and they're going across state lines trying to argue confusion, it's probably not going to work.
Yeah, and so for confusion, that's like another example. For the record, I have no objection to the Utah Brads being used. I don't think the likelihood of the confusion of the original real deal, and I'm in Dallas, and they're going to be in Utah, a separate state. I don't think we're going to have that much friction. So I'm not going to file any cease and desist letter if they go with that.
Plus, you sent a consent for them to use your image when you sent your vote in.
That's weird. How did you see that? All right, Jay, what did we find?
Yeah, unfortunately, we did confirm Pulse Point Health System had the federally registered trademark, but more importantly, it was registered in the same class that Dr. Gretzky would have been.
Yeah, and for our audience members, we're getting a little detailed here, but it's important to understand when the USPTO, when you apply for something, there are 45 different categories. Yes, I did say 45, not 50 or 100, just 45. 34 of those have to do with products, 11 has to do with services. And these categories are known as classes, and they're used to help kind of track these many 1,000 different marks when they register them. And considering like a word or logo could be working for some class and not for other classes. So you have to be very careful which class you choose. And again, an owner can choose one class or multiple classes to apply to, gain proper protection, because that's the whole reason why you're doing it when you file it.
What do you do about Brad being classless?
That hurts so
Ouch.
much.
I don't know. I mean,
I'm gonna start crying.
okay. Well, we've talked when we talked in a prior episode. We've used the example of Dove. Everyone knows that brand. It's well known as a shampoo and soap, but also a popular brand of chocolate. So they can coexist if they have these different classes. Jay, what did all this mean?
Yeah, I mean, sadly, this meant Dr. Gretzky was going to need to pivot, rebrand, which was, of course, both disheartening and disappointing. But it was also a great opportunity for her to revisit why she wanted to start the wellness practice and then come up with a name with our guidance that was going to be able to exist, but more importantly, obtain that maximum protection we'd want down the road.
Startup practices are in a tough spot because finances are tight, typically. And so the idea of fighting an unexpected fight over the name does not make sense. And so often the lesser of two evils is just to start over.
Yeah, it's always bad when the legal advice falls into the lesser two evils.
Yeah.
Nobody likes to hear, you have two really undesirable options here, and the end goal is to select the one that doesn't hurt as much or doesn't cause as much damage. All right, so now that we have these two evils, what was the next step helping Dr. Gretzky with her due diligence?
Yeah, we had her come up with a few ideas, and then we moved to the level 1 kind of clearance search, Google and USPTO, to start the due diligence process to see if those were going to be viable.
Michael, remind everyone, what is that? Why does it matter?
Yeah, it's the whole land grab. If they're using the name, they have to be first in commerce. So you have to see, is there somebody else out there that's going to have a greater right?
Yep, exactly. And so once we felt comfortable with one of the options, given Dr. Gretzky's experience, we went ahead and moved to the next step, level 2 search, where we had a third-party service go deep nationwide in a ton of databases around the country and see if there was any use of this trade name.
Yeah, and the second search is really like the trust but verify portion of it, because you can't just rely on what Google search says, and that's why their second in-depth search is required.
All right, let's go to break, and when we come back, we can discuss takeaways from Dr. Gretzky's story.
Many business owners use legal counsel as a last resort rather than as a proactive tool that can further their success. Why? For most, it's the fear of unknown legal costs. ByrdAdatto's Access Plus program makes it possible for you to get the ongoing legal assistance you need for one predictable monthly fee. That gives you unlimited phone and email access to the legal team, so you can receive feedback on legal concerns as they arise. Access Plus, a smarter, simpler way to access legal services. Find out more. Visit ByrdAdatto.com today.
Welcome back to Legal 123's with ByrdAdatto. I'm your host, ByrdAdatto, with my co-host Michael Byrd and series regular Jerry Arrow still with us. Michael, this season our theme is unintended consequences.
Yes, it is, Brad, and I've got a question for Jay. I want to explore these unintended consequences that Dr. Gretzky experienced.
Yeah, I mean, Dr. Gretzky's story was pretty straightforward, but one that, happens more often than not. I mean, she had a vision of a name and a brand that she wanted to build towards. She did a lot of the right things. She formed the entity, she secured the domain, all the stealth mode items that, Michael, you mentioned, and she even began developing the logo with trademarking in mind. So a lot of the great steps. The problem was she skipped the most important one, the very first one, and that's that level 1 search. She didn't check Google. She didn't check the USPTO database to see if there was anything out there similar, or, if there was, she could ask somebody, what does this mean for me?
Yeah, and for audience members to think about from this perspective, so back when I was a very young lawyer, 200 years ago, not as long as Michael, 900 years ago, but I had an MRI client, and they had set up this beautiful facility, and they had a huge sign. Like, think about the big signs you see in McDonald's, so that you could see it from the highway, so that you could find their MRI facility. And their sign was, or their name was, so similar to one that was like up the road, not even that far. Of course, this is before the Google and everything else existed, that it was like exactly the same. They got a cease and desist letter right before they were about to open. And they were like, "Oh no, let's fight it." And we're like, "Yeah, they have a trademark, you don't. They've been using it for like 10 years. You've been using it for 8 seconds." So they had to rebrand everything, including taking that sign down. And when they first looked into it, it was $20,000. So this is like 25 years ago, but still like very expensive for a startup to redo the sign. So they literally just hired some dude to put a blue tarp over it because they're like, we can't afford this moment to actually rebrand the giant sign. So that's how bad it is. And so just understanding, like, when you're getting ready to launch, think about your website and all the social medias and the names that you have associated with it. And all of a sudden, you now have to stop all of them and rebrand everything.
Blue tarp MRI.
Yes.
Yeah. Well, to your kind of add on to that, there's also an emotional hit. The doctors, have this exciting energy around the name for their business, and then this letter is like letting the air out of a balloon, and it can derail the focus on starting a practice, especially when you start fighting it. You're now totally distracted from all the things that you would need to be doing to be building a successful practice.
Right.
Yeah, and I think one of the big traps that people fall into is they get this false sense of security because they go to the state, they form the entity, and states have a similar, you got to have a unique name, and so they get it filed and they get it approved, and they think, okay, great, I'm home free. But the problem is that's just one state. That doesn't look into anything on the federal level in other states, and so they have this false sense that, oh, well, I registered with my state, so it should be fine.
Yeah, it's a great point. And, it's even confusing at the state level as to what you have, because states have their own rules on name permissions and how they grant them for forming an entity. And so I would say it's helpful to have a registered name. It's something, but it doesn't give you some level of protection that that people think they have, that to your point of being kind of false sense of security.
Yeah, and this is not to mention DBAs, which are also very common.
Okay, Brad, second vocab word.
Jeez, I'm getting hit today. So for those not familiar, DBA means doing business as, also referenced in many states like Texas, assumed name filings. These assumed names are an entity conducts business under a name other than the legal name that they file with their state. This generally means the entity is going to advertise this assumed name or DBA using this name on their business cards, letterhead, signage, anything, website that they have. Anyone who is interested in going this route, understand that, as Michael kind of alluded to, if you're filing a name, the actual name with the state, you have a little bit more protection than a DBA, because DBAs by themselves don't typically have the same protection that you would have. And obviously, filing something with the USPTO's office is the ultimate protection. And for example, if I formed an entity called 1208 Camp Street and marketed as the whole world, my website and everything as Bad Brad's Beer and Beverage Bar, that would be the DBA.
Nice.
And although it would be really cool places now that I'm thinking about.
Kind of
open it up in Utah for some reason.
Yeah, supply the Utah Hockey Club, DBA Utah Brads.
Yes.
Yeah.
Yeah, so eventually, to kind of wrap up what happened with Dr. Gretzky in her practice, because we worked with her through the entire process, we went through the steps in the order that they did. Even though it was an emotional roller coaster and she suffered some setbacks, we got her to a place where she had a great brand name, a renewed sense of excitement for this vision. It was able to get trademarked, and we had no issues with it. And so for the audience out there, the name was Alpine Vital and Wellness.
Oh.
I know Brad's disappointed again.
I
know.
My name just would be help there.
DBA Brad.
Yeah.
All right, Jay, final thoughts?
Yeah, due diligence goes a long way. You get through excitement. You have these visions and ideas of what it can be, but you really need to kind of take the first step, do some basic due diligence, go through the process before you get too far down the road and kind of have to turn back around and go the other way.
Michael, final thoughts?
Yeah, one thing we didn't touch on, but it's related, is we have clients who like to collect trademarks. So they have an idea, and they're like, I want to get a trademark on this, and they'll have a big list. And a long time ago, trademarks really carried a lot of value to the business, and so I think there's still that perception. Or it's just, they have an idea, and they want, something to validate it. And again, it's so important as a final takeaway to not lose sight of, you need to be using it. You need to be the first one to be using it. And so, volume high volume doesn't necessarily mean value.
Yeah, Brad.
Fair. Well, I'm not following your statement there, Jay. And thank you for joining us, apparently. All right, audience members, that's all the time we have today. But next Wednesday, we will be back with Unintended Consequences when Michael and I are together without Jay. And we have another hot sports topic here when we talk about the unintended consequence with paying commissions in a medical practice. Thanks again for joining us today. And remember, if you like this episode, please subscribe. Make sure to give us a 5-star rating and share with your friends.
You can also sign up for the ByrdAdatto newsletter by going to our website at ByrdAdatto.com.
ByrdAdatto is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does it establish an attorney-client relationship. Reference to any specific product or entity does not constitute an endorsement or recommendation by ByrdAdatto. The views expressed by guests are their own, and their appearance on the program does not imply an endorsement of them or any entity they represent. Please consult with an attorney on your legal issues.